We now have the final panel session for the day, but before that, I'd like to make an announcement. Right after this session, we're going to have a very small interactive activity that's going to happen, through which we'll decide the 5 lucky winners who will be getting the Thomson Reuters prizes, for which you would have had to fill up the survey forms by then. So request you to kindly fill up your forms so that you're eligible for the lucky draw. Moving on, I'd like to call upon stage the moderator for our next panel, Ms. Kasturi Ghosh, partner, Trilegal. Her primary areas of practice are telecoms, technology, corporate, and regulatory work. She has advised on numerous global technology and telecommunications transactions with multinational companies. Some of the clients that Kasturi has worked with are Telenor, Unitech Wireless, Vodafone, Wolters Kluwer, Covidian, OLX Inc., On Process Technology, Computer Science Corporation, Abbey National Bank, Strand Life Sciences, and ETM Technologies. Please put your hands together to welcome Ms. Kasturi Ghosh. Thank you.
Good evening. I think we've got the graveyard shift, so we've had a bunch of people who've left since the last panel, but I think let's keep it lively. I think, the room is still quite full, so thank you for staying. And, let's try and do the Q&As as much as we can. So let me call onto the stage the rest of the panelists for this evening. Debolina, could I ask you to please come up? Debolina is the Vice President and the GC of the Walk Hard Group. Next up on the panel is Shubhadeep Sharkar. Please come up on stage, Shubhadeep. I think he's with the Cognizant Group. He's a senior director and manages the IP there. Lakshika Joshi is our last panelist for this evening. She's GC with Nucleus Software.
Absolutely.
All our mics are working. Oh, you have to share with you. You have to share the mics. Okay.
I think we're audible enough, so.
Yeah, actually, perhaps we don't even need some. So I think this is going to be a session which I think cuts across all of the industries that we work with. We're going to be talking about IP, which I think has become the hot topic of the day. I remember a time when I, as a lawyer, started out. It was about 15 years ago, and in this city, when I joined my firm, the technology work that we did was pretty much outsourcing. And really, over the course of the years, the kind of change that we have seen within our own ecosystem has been fantastic. Yesterday, I think the FT, there was an article which talked about how Bangalore has changed from becoming like the back office of the world to pretty much at the forefront of startup and new age technology culture. And not to leave the pharma side of it out as well. So I think with that kind of a shift in gear, I think let me ask the first question on technology to Shubhadeep. What, since you have been responsible for pretty much creating an IP cell in Infosys and here as well at Cognizant, how are you going about the process of actually effectively monetizing your IP? It's a large question, so
Yeah. So, when I started IP at Cognizant, obviously there were a lot of challenges, primarily because there was some processes obviously were there, but it was not integrated. So if you're talking about monetization, the first thing is that you have to set your house in order to have your portfolio. And once you have the right portfolio, then you have to actually analyze the portfolio, identify and bucket the portfolio into various components to see what you want to monetize and why. So there has to be a clear monetization strategy before you can even start doing it. Now, once you have the strategy and you have analyzed the portfolio, then obviously the question comes is how do you monetize? So you have to understand what is happening in the market. So you have to get an outside in view, trying to understand what competitors are doing, how strong is your actual portfolio. Now the portfolio may not contain too much of patents, but if you really look at your product portfolio, it may have a lot of commercialization value. So you have to do those analysis and then look for potential licensing opportunities. So obviously, every company has different strategies again, and it is not that one company needs to follow the other company just because they have been successful, because you have to tune your IP strategy aligning to your business strategy, and that becomes very important, and therefore your monetization strategy may also change. So you may not be totally offensive always. You can start with a defensive approach. You can start looking out for potential licensees, and then start commercializing. So the strategies will vary, and what I have seen is it is very important to spend that initial period doing the proper due diligence and then going to market for looking at commercialization.
So, Lakshika, something which Shubhadeep was saying, that you have to do your DD first. You have to understand what your IP is. And since you come from a company which is into the product side and not just the services side, how do you see it? Do you see it in a different manner? Do you see some additional layers of complexity that you need to look at, to tackle, in order to be able to understand which IP you want to actually to put out there in the market? What is the go-to-market strategy that you want to create?
Thank you. So I think in most of whatever Subhadeep said, I sort of agree with that. And in fact, I would like to add to that IP experience of another kind, because I'm with Nucleus Software for only about 2 weeks now. And before this, I spent more than a decade working with the Times of India group. And the kind of IPs that we saw there were very different from, the software IP that we talk of at Nucleus, which is an IT product-driven company. So I think he made a very good point, and couldn't agree more with it, that you need to actually first have your house set in order. And that is extremely important. So if you have to have a robust IP licensing strategy, you have to first understand what are, not just what your strengths are, but where your weaknesses are. And you need to be able to, in some way, shape or form, either plug them or mitigate the risk associated with that. And again, if we talk of products and we talk of patents, there's only a limited life. So IP is, exclusive right for a limited period of time. And as a business, one would want to leverage it the most for that period. It works slightly differently when we talk of IP pertaining to copyrights, IP in film and music and other pieces of work that are literary or artistic in nature. But even then, there is a life to it. And again, adding on to what he said about, you have to have an analysis of where you are in terms of the market reality. Sometimes you may have excellent products, and you may have an IP over it. You may have an IP policy, an IP licensing strategy in place, but perhaps the product is not in demand at all. So you have to sort of balance out. You have to understand that every product or IP company does have a vision, and it's the ideal situation to be saying that, I want to start monetizing my IP. But the ground reality may be something which is absolutely different from that. I need to understand where my market is, who my customer is, which are the territories where my IP would go, and hence your IP licensing strategy will then be driven or perhaps framed accordingly.
Thank you. So, Evelina, from your side, being so heavily into the R&D space, where do you see, the market, and how do you kind of give an input to the commercial teams, to the business teams around what are the next steps, in relation to new drugs and new areas that Walkhard is going into, or any other company is going into?
Thank you, Kosturi. Ladies and gentlemen, please forgive me. I have a slight cold, so I may sound husky. Kosturi, firstly, taking a pitch from the last panel, part of my compliance, I have a disclaimer. Whatever I speak is my views and not my company's views. Secondly, I'm not permitted to speak about Walkhard much, except maybe a couple of things which are in the public domain. Now, in terms of how we advise stakeholders, business partners, be it the marketing or the R&D or the supply chain, when it comes to IP, it's very important that we know what that particular team is aiming at with a counterparty. That is the first thing. It's like knowing your partner and knowing your partner's partner. Once you know that, then you can work around your reference. Now, actually in the R&D and in the patent space, it's very rigid. The affordability to, take risks is very limited. There are very few companies who have policies like Cipla, who go very bang on and, get into the new product markets where, they are still in patents and innovators fighting them. So we need to be very careful. We need to check on the jurisdictions across where the patent exists, when it is getting off patent, which jurisdictions permit data exclusivity, which jurisdictions do not. So there is an immense planning in terms of applying for the ANDA or the drug, or if it's purely a generic entry, which is after it has been off patented and there are already generics in the market, then what is the branding strategy? So all these things are considered before we give the ideal set of solutions in IP to the marketing team or the sales team or the R&D team.
So, Shubhadeep, you mentioned that it is important for a company to understand what its competitors are doing. So I think that brings me to my next question, which is how much is competitive, the knowledge, the CI, as it were, how relevant is that? How do you go about actually assessing what the relevant CI is to the company, and then kind of sifting through that to be able to understand how you need to define your strategy vis-a-vis the CI that is out there in the market?
Right. So CI strategy has changed over period. I mean, if you really look at how CI used to be done 5-10 years ago and how is it done today, it's slightly different. Now there are again, it all boils down to what is the objective of doing a competitive analysis. So there can be multiple reasons, but one of the main reasons is if you want to understand the overall market, the trend, or how the patenting trend of your competitors as well as others are moving. One of the recent change which I have seen is it's not only about the patent data that you analyze, because we all know that patent data is an 18-month-old data. Now, if you really want to understand technology change and the speed at which technology changes today, you have to combine with different elements or different source of information. It can be a non-patent literature, it can be even a social media information. And then you collate and correlate these 3 set or 4 set of data and then come out with a conclusion. Because if I'm let's say a professor in some big university, I have filed a patent, I have written a paper, and I may be blogging also. So now if you are waiting for my patent to get published and then you trying to find a trend, you're already late. So therefore, you have to come out with new methods and means to analyze the data And there are obviously new technologies coming out in how to analyze data, and then correlating this data, saying that, okay, I have talked something great in the blog, but my patent may not be a very strong patent, or I may not be a real genius in that field. It may be a one-off case that I would have blocked. So you have to understand my strength and then do all those analytics and then come out with the CI. So CI, the way CI is done and why it is done has changed over period.
Ashika, and any thoughts at your end? I mean, if you're looking to, for instance, go into a new market, how do you use CI, and what are the kind of other factors you look at when you enter a new market? We were talking earlier, and you were mentioning, because you tend to operate in the banking sphere, you are bound by certain rules and regulations of new jurisdictions and things like that. So can you give us a little bit of an insight into that?
Sure. So if I may talk beyond CI, and address the second part of your question first, we have software products that cater to the banking sectors, and these are lending and cash management software products. So interestingly, we have operations and implementations across 50 countries besides India, and every territory is very different in terms of the regulations, the local laws, and various other guidelines. So there will be RBI equivalents in those territories. There will be separate set of local regulations. So even within Africa, each territory in itself is very different. And what we need to then constantly do is take a core product, which is the IP, and constantly sort of improvise it or give it that local flavor. So, it has to be compliant, specifically because we are in the banking and financial sector. It has to confirm and be able to integrate the local regulations, the local laws, and these keep changing. So every year we have the finance regulations that keep changing, and it's pretty much the same across the globe. So the software needs to be able to implement and incorporate each and every change. There may be a change that is not sort of within the product cycle as we planned it, but if that is the requirement of a territory, we have to do it. So that is on the software side. Then when you work across jurisdictions, there are issues that pertain to the trademark side of your IP, You may have a well-established mark in the country, but when you want to take the same mark to another territory, you may have objections, you may have similar or deceptively similar marks already present in those territories, and you may then need to modify that mark. You have to be extremely careful and sensitive because, again, the same laws are not applicable. So if I can just borrow an example, the French laws work, or the French courts interpret trademark laws very differently from the US courts. So just for example, before 2005, the French courts were actually taking cognizance of anything or any website that was available in France, and that was their criteria of deciding where the jurisdiction is or where the cause of action lies. So if the website is actually a Spanish site, and it, just giving an example from a case that comes to my mind, and it happens to use a mark called Crystal, which also happens to be the mark of a French sparkling wine, the court will take cognizance of the matter, and just the mere fact that the website is accessible from France is good enough for them. So of course this was later settled. There's a famous Hugo Boss case that settles this, and now the courts are a little more conscious of technology developments in a way that territorially you cannot sort of limit the application of trademarks. And now they rely more on language, on what was the target audience of the mark or the website, the way it was accessible. So that's on the French side. But contrasted to that is some other judgments from US courts where you know, the US courts actually held that some of the Canadian websites were infringing on trademarks. So there's a famous homeaway.com case where, you know, they said that, a person happened to register, a Canadian resident happened to register a trademark which was VRBO, I guess, and that happened to be also a mark used by homeaway.com, which is a very famous US mark and a US website. And the US court said that the site shouldn't be visible, and you know, it was an infringement as per the US Act. So, you know, I may have an established mark, I may have a registered IP in my country, which is my homeland, but when I move that IP outside and I cross borders, I have to be very conscious and mindful of how those jurisdictions are interpreting these. And I guess that should go into when I plan my IP licensing strategy. So I need to be extremely careful about the territories that I intend to go into. I need to have constant dialogue with my business teams, with my strategy teams, and figure out what is the long haul for my IP, what is the long haul for my business rather, and accordingly factor in all of this.
Thanks. So Paulina, same kind of a question to you, that when you are entering a new market, you know, there are a whole bunch of issues, of course, that we know plague the pharma sector as a whole. So, but could you sort of look at both the patent side as well as trademark trade dress, as we were discussing earlier?
I think before we go into a new market, at its inception, there has to be a core decision as to whether a particular product is for only an India market or India and South Asia market, or it's, you know, an EU market or a US market, because pharma sector works, either it works globally or it works in fragmentation. So that is something which is decided as a policy between the stakeholders, where obviously the IP team as well as the legal team is a part of it. Once that is decided, we check for the availability of the marks. I'm first discussing on the branding and trademarks. So we decide on the marks, available marks, and once we come down to, let us say, 4 or 5 options, we get into the various jurisdictional searches. So again, you know, I can say that either we do it individually with the jurisdictions or we go through a Madrid protocol. Depends which is more, I would say, business convenient as well as cost convenient. Without undermining, of course, the legal nuances, you know, we don't undermine that. And one should not undermine that. So based on that, then we go for the registrations. It does happen, as Lakshika says, that in many jurisdictions, those particular marks may not be available. Or sometimes those marks mean completely different in those jurisdictions and may not relate to the product. So in that event, we go for another mark. Same thing, along with the mark, the label and the trade dress goes together. You know, we have, as I was discussing with you, you know, during lunch, sometimes, you know, generics, they would come out with a label which is very similar to an innovator or a proprietor company. Let's say the label is a combination of a white and a yellow. And the generic would always want to be as close to that label so that, you know, the public identity, okay, this is the well-known product in the market. But it's a very big danger in case that label is registered, or even if it is not registered, you could be either infringed if it's registered, or you could have a serious passing of action against you across jurisdictions. So it's very important, though you know your marketing team may come and tell you that white is a color which is common to trade, or yellow is a color which is common to trade. But you must tell them that in a combination of white and yellow with this particular yellow shade, it doesn't become common to trade. So we have to be very careful while selecting not only the mark, but along with it, the trade dress, the labels, And if we are into, like for instance, if we are going into the fields of insulins or respiratory, you have the device along with it. So you have to do a very thorough design search, which, let me tell you, is more difficult than a patent search. Because in many countries, the designs, there are no defined design laws. India, you have a design act, but like many African countries, some of the Asian countries, some of the Balkan countries, they don't have defined design laws. So that time you have to do the common law search, you have to do the design law. There are many judgments in these jurisdictions which get into the, they are treated as patents. So there are additional complications. But please, it's very important to time your product after you conduct all your searches. So if you know that your product is going to come 18 months down the line, please have all your searches and your applications in place prior to that, and not to go in the last moment. Many a times it happens, oh, it's available in EU, it's available in US, so it will be available in the other countries. It doesn't happen so. So we must be very mindful of that. As regards patent, I think the laws are very clear and defined. Personally, if you ask me, as a general counsel, as an IP practitioner, please don't take risks. Please, we should be very less maverick in this area. And let us not, have unnecessary fights. Of course, it's very lucrative if you, win on the other side. Nowadays, even settlements are very tough. They get into antitrust vigilance. So my personal view is let's not risk too much on the patent side. Thank you.
So I think that brings us to the next question, which is around this whole litigation, IP litigation. Is that being considered as a monetization tool? Because the number of cases that we are seeing both here in the US and the Western world has increased manyfold. And while there are some discussions around FRAND and things like that, question is, are we able to really understand what is fair and reasonable, and how do courts in India see that? So Shubhadeep, to you, what are the kind of things that keep you awake at night?
So that's a very tough question, because if you start listing down, then we'll never finish. But talking about FRAND, obviously that's again a very debatable subject. And from my perspective, we have not participated too many on the patent pool collection for the FRAND on the licensor side. But obviously we are users or consumers of those licenses. Now those negotiations obviously can be really tricky, and there are tons and tons of issues around FRAND, even starting from confidentiality to the terms that will be decided, what are the restrictions that are there, and so every FRAND licenses they have different kind of terms. But overall that is always tricky, number one. Number two is, if you look at software industry, I can give software industry example. One of the things which really has changed over the last few years is the intensity of doing collaborative innovation, which I'm sure would have increased in other domains also, but the dependencies on various third-party vendors, because the software today does not get developed by only a proprietary methods or systems. It is a combination of a lot of other technologies. So now when you have that, then obviously the IP attorney has a challenge in terms of negotiating this and negotiating all your vendor deals, and then having those pass through to your outbound. And as Debolina was also stating, that we need to understand the customer's customer also in software, and for any domain today, because it becomes important for you or the attorney who is negotiating to visualize that what may happen 5 years or 2 years or 3 years down the line, and you have to structure the deal accordingly. So I have seen that most negotiations take a lot of time, and it fails eventually, few of them, because the structuring of the deal was not done properly. So just like, if you want to monetize license IP, you have to, plan and do the due diligence as we discussed. In negotiation of IP transactions, you have to structure the deal, spend more time in structuring the deal, and then moving to the next stage. It becomes much, much easier. Have all the parties involved, because every party has their, they want their own pie. And if you understand what they want, you can really create a win-win scenario in today's, transaction. Because everybody is keen to make money, everybody is keen to close the deal. So it's not one party who is playing a monopoly game here. So you have to understand that. And for collaborative, innovations or collaborative, those kind of work, IP ownership, of course, becomes a challenge. So there are other challenges which are general. I mean, everybody, I'm sure, in this room knows about it. But these are some of the issues that obviously is a challenge, I would say. Oh, I have a mic, sorry.
So I think the question to you is, how are you seeing the trends in litigation in the pharma space? I mean, the whole, we've gone through the gamut of the compulsory licensing that's been beaten to death. The USTR's report on India. The questions around the revocation of all the innovator patents. The Supreme Court going one way, the IPAB going the other way. Injunctions being granted on an interim basis. What's your sense of how India is going about this kind of a process? What are the kind of key trends you're seeing? How do we kind of ward off any particular issues that you see today?
Kosturi, you asked a very interesting question, very close to my heart also. To begin with, I'll be a little maverick.
Just now asked us not.
No, that was for risking to introduce drugs, which is in patent. But now you speak of compulsory licensing, so please permit me to be a little maverick, because I'm going to give one example, which is not traditionally what we are talking, IP, or compulsory license, as we all know. And we have studied and we have also read a lot about it. I'll go back to 1945, or even prior to that, 1920, when Mahatma Gandhi started the non-cooperation movement, and his great concept and ideology of non-violence. Okay? And it was a great success. And it was like he was the proprietor of, that ideology. 20 to 30 decades thereafter, you had somebody from the US, Martin Luther King, adopt the same thing without any consent. And it was again a great success, So, if such a compulsory license can be great success, I don't know why we are speaking so much and crying so much about it. But I think if you really ask me, and this is a really radical view from me I'm giving you, today what's going on in the compulsory licensing field as well as in the patent field, whether it is evergreening or pay for delay, and pay for delay is reduced after antitrust. I think it's more of emotions and public sentiment and less of law. And I'm sure the generic companies will not like it, me speaking. But I think it's more of, if any one of us have read the judgment of Novartis and Glivec, and also Bayer and Natco, a lot of Indian government's adoption of TRIPS and the philosophy Indian government had why it did not adopt it fully was put into the judgments. And there they say that, there should be affordability and accessibility. And the innovators are not matching up to that. So can this be above the law? See, one is, you are really, if a patent is just not qualifying for an upgrade, I can understand, that getting rejected. But if it's a valid patent, which is getting, into a different combination of a molecule, but it is not being granted because of sentiments, I think then that calls for some seriousness. Of course, our Prime Minister has promised a lot of things to nations outside India, and much is to be seen how much it is to be implemented. But right now you have innovators fighting generics, you have Novartis fighting Glenmark, Cipla, you have Roche fighting Cipla, you have Roche fighting Natco, you have Novartis fighting Wockhardt, you have Novartis fighting Lupin, so you have AstraZeneca fighting Biocon, so it's all there, some winning, some not winning, some licenses have been rejected also. So, but I think at the bottom line, there's a lot of public sentiment which has gone into these judgments. And I don't know whether I can call it judicial activism, but there has been a lot of judicial activism. I'm not saying that poor people should not get the medicine, should not reach the medicine. But your basic ingenuity should be protected. That's very important. It should not be laid as a precedence. Okay, in a particular case, yes, if Gleevec, which was a Novartis patent, has been proved not to be an creative new work, I can understand. But if it has just been rejected for an affordability or, it has not worked in India, of course, that's one of the provisions of the requirement of being a grant of patent. It should not be shrouded with public sentiment. I think the law should be given respect. The creativity in the law should be given respect. That's my take on these litigations.
That's actually quite a maverick take coming from the generic industry. But you certainly are right, and we've seen this kind of a bit of a flip-flop even within the government itself. I mean, with Narendra Modi once saying that our patent act and patent laws do not match up to international standards, but the commerce minister on the other hand saying that we are compliant with TRIPS and therefore there is no reason for us to do anything in a different way. What's been your take of the national IP policy, which has just been introduced? I know it's a topic that can perhaps go on for an entire session, but some quick thoughts I think from all of you. That'll be quite interesting.
Yeah. Sure.
National IP policy, December 19, 2014, right? The draft. I think it has everything under the sun.
Promises everything.
It promises everything under the sun, but I didn't see any timelines. Like, for instance, they talk of traditional knowledge being legalized and, having a full set of laws behind it. They talk of digitizing IP. They talk of more patent benches in the high courts. They talk of IP exchanges. They talk of more centers of the IPAB. But when, how, as you rightly said, you've been looking for an NCLT since 1956. So this has just come in 2014. So I just hope the proportion is not the same. But yes, the policy, if it is implemented, and Pratibha Singh is one of the members of the think tank, if the policy is implemented, I think India can go a long way ahead. It'll be a big leap for India. But at least I don't see it happening in the near future. It will take its own time. And with such, big ticket items, I think first it needs to, whatever is existing, that house in order should be done before it takes its leap into, such big concepts.
I completely agree. I mean, she's absolutely right. The main problem is around implementation, which is the key. I mean, it's like a story. So it's a good storybook, but then end of the day, it has to be implemented and there has to be an impact, right? So there can be many things one can do in terms of implementation, but three things which I feel are very important and should start immediately is there has to be a an ecosystem created by government to commercialize and monetize IP. You talked about in the initial time, startup culture. Now, how will the startup actually, commercialize? Is there a platform where they can really commercialize? Second important thing is around improving the overall operation and administration in the patent office, which is again a challenge. I mean, we all know how much time it takes to get a patent granted in India. So there are, huge amount of administrative operational challenges which needs to be sorted out. Third is there has to be good and impactful programs on training, and it should start from schools and colleges, because that culture is very important. End of the day, we carry that culture of not complying to IP, and then we move into corporate world and we have problems there. So it again links to the overall compliance. Today, if my daughter is trying to do a project work, I'll say, let's start with Google, right? So that's a immediate tendency. So now, if you don't respect others' IP, your IP will not be respected, and that should be taught from the grassroots level. So training, while government has a lot of programs, even the trade association, trade bodies, they're doing, but it has to be structured and planned well. Therefore, three things I have told, but there can be many, and it has to be taken in phased manner. So as long as the implementation is done, then the policy will be good.
I agree actually with Debulina and Shubhadeep, and the policy is more like a vision statement, without specific timelines and specific plan of action. Beyond that, I think the government has to be a little more careful when actually implementing and micromanaging that policy. So just for example, we were discussing that there has been recent amendments to the Copyright Act in 2012. There was a huge debate around many of the provisions that pertain to lyricists' rights, performers' rights, and so on and so forth. And these were being debated at various forums. And what then came out was, in form of an act, also had 65A and B in it, which actually is not in compliance with TRIPS. It's a TRIPS plus, So I'm not sure how and how we see that rolling out. So 65 actually talks of, it makes circumvention of digital rights management technologies into product actually an offense, and it goes on to describe what the circumvention could be and what could be the penalties and charges, and it also makes it criminal. So are we going overzealous with trying to implement some of the things such as digital rights management, and are we close to the ground reality, which is of a developing nation? Or are we just trying to be, are we copycat, or you may say that, we're just overzealous. We want to be TRIPS compliant, but here we've gone ahead and been, we've adopted 65A and B, which is TRIPS plus. And is there a research available that, shows that, or was there any debate on the, subject which could prove that a country like India, which is a developing nation, needs something like that? And similar researches have been done in some of the developing countries where they thought that DRM is something that they want to keep out of their statutes for at least a couple of decades, because it works differently when it is applied to a developed nation, and IP coming from the developed nation to India. So if I may bring your attention to an interesting observation, and this is from my past experience of having dealt in copyrights for more than decades, that 80% of the IP, at least in the copyrights domain, is actually, and I'm limiting myself to English language, is what gets imported into the country. So if majority of my IP is what is getting imported, and in India we're only consuming it in form of licenses, are we justified sort of framing our laws and giving them the shape as a developed nation would have it? Even in the US courts, provisions that are similar to 65A and B pertaining to DRM have at times been upheld by the courts to be over stringent in nature. They've come under the scanner of antitrust issues, and so perhaps at some point, implementation of a policy which is a vision, it needs to be considered how far we want to go with that implementation and to what level. Perhaps we need to balance out the realities of the nation with how we want to project the policy to the rest of the world.
Thanks for that. I mean, do you see the changes to the fair use, the fair dealing parts of the Copyright Act trying to address that in some manner?
Oh, it looks like we're running out of time. Okay, so no, not really. It doesn't. And again, since you mentioned both the words, let me bring this to everyone's attention that in UK we follow the fair dealing, and in US we follow the fair use concept. And the fair use is actually much more liberal than fair dealing. So just by way of example, fair dealing does not include unpublished works. And the US Act goes a step further when it defines its fair use, and it also includes published and unpublished works into it. So I don't see that. I see in terms of fair use, our statute is pretty robust. And more than that, our courts and judiciary has been extremely creative in interpreting it, and rightly so. So, we've had cases like Starr versus Piyush Jain where, math scores were sort of held to have been an infringement of hot news rights and all of that. And I think the courts are extremely conscious of the fact that the interpretation of the fair use concepts has to be a balance between the rights to the end user and the benefits to the end user and protection of the owner's copyrights in the embodied work. So in that respect, I think our courts have been extremely good and extremely logical with the way they've interpreted most of them, because even in the US, there have been conflicting judgments on this. We've had several cases where hot news was held, so I'm sorry, I mean, if it is a new concept, let me just say what hot news is. So hot news is actually the minute you release a news item, immediately if I copy it and post it on my website, is that an infringement of my IP or not? If that is the question, the courts technically would say that there is no copyright over news because news is exempted from it. However, in the US courts, and there's been a landmark US Supreme Court judgment of Associated Press versus INS, where this principle was first time laid down, which said that copyright in a news item has to be seen in the light of quasi-property rights. So there is a time frame, perhaps half an hour, 5 minutes, 2 hours, or whatever that time frame is. It's been interpreted differently by various courts. Till such time, that news item is hot property of the owner, because the owner has put in a lot of efforts, a lot of manpower, energy, resources into generating that information. They may have, so if it is a piece on war news, they may have sent out their reporters who are risking their lives and being out there in the fields reporting that piece of news. So for that limited duration of time, that news item is actually then treated as quasi-property, and the owner has exclusive rights on it, and even though it is news, you cannot sort of use it. So this concept then was later in many of the other cases in the US courts questioned, and upheld differently. And I think, again, a very interesting case that we discussed, which is Star versus Piyush Goyal. The Indian courts have been extremely judicious and extremely mindful of the ground reality in interpreting it. So they actually said that if done with a lag of, say, 5 minutes, it's okay. Because it's news, the public is entitled to know what the news is. So the courts are mindful of the fact that if certain things are to be done for the benefit of the end user, they should be done. However, at the same time, the courts are also conscious that the copyright owner has put in substantial efforts, money, energy into gathering that piece of news. So they've built in a 5-minute lag into the process. And in that 5 minutes, they have enough time to sort of monetize it through SMS, through flash items, or whichever way they need to.
Thanks, Lakshika. Do we have time for questions? Or?
Just an observation on the same matter. The subsequent decision of the latest decision of the Delhi High Court by the divisional bench, wherein it is said that no quasi-property right exists as far as it is news and as far as there is no infringement of copyrights. More so when, in this particular case, BCCI and Star themselves admitted that they are not, what their claim is dehorse the Copyright Act.
Yes, and they're also talking about related rights.
Yeah, but the court struck it down. Yeah. So the matter is now before the Supreme Court.
Yeah.
Yeah, and the last.
So thank you again for staying. It was a good session. I think we dealt with a whole host of issues. It's worthwhile to always keep our IP laws at the forefront of our mind. So just like we had the previous panel talk about the compliance issues, I think there's very little a company can do if it doesn't look at its IP strategy and how it plans to use that as part of its business. So with that, I hand it over back to Divya.
Thank you very much.